Another divisional application of the petitioner was dismissed.
With leave of Mr. Dave, my lord, I appear here. We challenge, my lord, the arrest of a person who is in custody to whom the ground of arrest was not supplied. So that was the subject matter, my lord. Nothing to do with this petition. No correlation with this.
But in this revisional application also, you have taken the point of section 47. Compliance of section 47. I have seen.
Yes.
Yes.
But he's not arrested. So.
Very well. Well, Mr. Dave, please move the writ petition fast.
Yes. I'm obliged. My lords, we are constrained to move this, my lords, in the most peculiar circumstances. A police officer, my lords, is on patrolling duty in the hours of 29th of July and 30th. 28th and 29th. Early hours of 29th. He gets at 3:15 a.m. a secret information that in a particular house of a particular person, my lords, there is stashing of cash and of some material, and therefore there is urgency at 3:15 a.m. that the premises be opened and investigation commence. He informs his superior. Superior says yes, do it. Makes a general diary entry at the police station. He doesn't go, but it's done over telephonically. And with the police force, he goes knocking on the house of the present petitioner's brother-in-law. The house is not open. They use force. They enter. They ask the persons who are there. There are some women. There is the brother-in-law, that we have come. We have information. We want to search your house. All that is done in the early morning, and in the search, they find there are gold bars and cash items which are present there. Some of those items are in boxes, some are in almirahs. Those almirahs are broken open, and then they are seized.
No, items are found, if I am not wrong, from cupboard.
Yes. Almirah, my lords, are where they say the cash, etc. is all stashed. And then there are gold bars also. They call some jeweler to verify whether the gold bars are authentic, etc. And thereafter, my lords, the person, that's the brother-in-law, he is taken to the police station.
After 26 hours.
And he goes to the police station, my lords. And at the police station, his statement is recorded, in which it is a confessional statement which is recorded. All this, my lords, is from the record. Thereafter, my lords, at the police station, an FIR is registered at the police station. All this till the investigation of till the registration of FIR investigation has already taken place, which is entry, search and seizure, and arrest. All three acts have taken place before the registration of an FIR. Now, in the confessional statement, and what comes to that, sorry,
I'm interrupting you. Under section 106.
Yes,
ENSS.
Yes.
Is there any bar if there is no FIR is not subsisting?
No, my lords, not a bar, but in the peculiarity.
6.1 doesn't impose any bar, explicit bar.
No bar, my lords, but in the peculiarity of how it is. Suppose there is a cognizable offense taking place, in the sense why there is no bar, I may explain, my lords. A murder is taking place and an accused runs into a particular house and hides himself. Police officer is there, he has seen that particular act being taken. He then has to open the premises and apprehend that particular accused persons. So an offense has taken place. Here the offense is taking place before, from a source information that this particular police officer is supposed to have. Who has told him? We don't know. And please, when I take your lordships to the FIR, I'm sure your lordships have already gone through it. The FIR is so detailed as far as what was the allegation. There was illegal sand mining, it was happening. Now, there was one preliminary point. Possession of currency notes in my house and gold is not an offense under the IPC. It is only, if at all, an offense under the Income Tax Act. Only the income tax authorities have jurisdiction as far as cash is concerned in a particular house. Then it is upon me to explain to the income tax. And that is why, my lords, your lordships may bear in mind that income tax offences are not as scheduled offences as far as PMLA is also concerned. So if I am found in possession of cash which is beyond my known sources, not in the prevention of corruption sense, but beyond, as a private person, I have cash in my house, my lords, then it is no offense for the police to start investigating that we have found so much
But
cash.
whether we keep cash in cupboard,
Yes, my lords, for safety.
it may not come under the purview of, as you are saying,
Yes, my lords.
it does not come under the purview of BNS. Rather,
my
it
lord.
comes under the purview of Income Tax Act.
Lordship, please.
But whether a prudent citizen
Yes,
or a man of ordinary prudence keeps those items in the cupboard.
yes, my lord. I'll indicate. There are certain business transactions, my lords, in India, which are also primarily based, my lords, on cash transactions. Selling of country-made liquor, my lords, is based on cash transactions, where people come and buy, my lords, for small amounts of money. Those are the things. Here also, as far as mining is concerned, it is there. Now, please, when your lordship sees the FR in the facts of this case, that at 3:15, they could not wait. What is the source information, my lords? Nobody knows about the source information, who this information has come from, that this particular person. And I am not even in that house. Please bear in mind that part, my lords. It is not my house. I'm not even in that house. I'm not even present there.
You have left country on 23rd of May. As you have
So,
stated.
yes, my lord. So I have gone, my lords, on 23rd May. This is happening on 29th of July. And therefore, they go to my brother-in-law.
Why you have left country?
I've gone, my lords, to roam around. It's a, my lords, to
Roam around.
roam around, my lords. It's a,
So you have left the country on 23rd of May, and this seizure was made.
But they-
Some valuables are not some huge valuables
all
are
right, my
found.
lords. Yes.
And you are saying that this court will exercise extraordinary jurisdiction, which is not a routine procedure
No,
as contemplated in Niharika infrastructure.
Yes, my lords. I am praying for your lordship's consideration.
And the investigation is at the nation stage.
My lords, the section that has been invoked, section invoked is 111, which is organized crime
Please come to page 127
of the paper book. my
of the
lords.
writ petition.
Yes. So, my lords, please mark, my lords, as far as quashing is concerned, your lordships will see the ingredients of the offences. The
Please
offense.
come to page 127.
127 is in second one. Yes, my lords.
Please place remarks column
Remarks. my
or
lords.
the
Yes.
narration under the heading remarks.
Yes, my lords. The search and seizure operation was initiated in the early hours of 29/7/26 on the basis of credible source information. The commencement of search was initially delayed to the non-cooperation of the occupants of the house. Upon completion of the necessary legal formalities, the search and seizure proceedings commenced at 5:52 hours on 29/7/26 in the presence of witnesses named herein. The property is two-floor building with 5 small rooms on each floor. As the search progressed, and substantial quantities of Indian currency and yellow-colored metallic bars were discovered, additional police officers and force was requisitioned and subsequently joined the operation to ensure the safe, systematic and transparent conduct of proceedings. Now, the milords, the persons are mentioned therein.
Yes, yes.
During the search, the seized properties comprising of Indian currency and yellow-colored metallic bars were, there's a stamp, were
Yellow color metallic bars were
recovered
discovered.
principally from two locations within the house, namely cupboards situated on the ground floor and cupboards situated from on the first floor. On the ground floor, one cupboard described under Exhibit V was found containing 25 bags filled with Indian currency note. Each bag was opened individually in the presence of the witnesses. In each bag, handwritten slip indicating amount was found. All such slips have been seized as Exhibit 59. Currency was removed, sorted denomination-wise and counted. Considering the exceptionally large volume of currency recovered, additional currency counting machines were arranged through liaison.
What more is necessary at this
Milords,
stage?
it's not me. Milords, kindly bear in mind, Milords.
But the suspect comes to
He's
be
arrested.
true. Suspect comes to be true.
He's arrested.
The suspected, the officer, the concerned police official who suspected and entered into the premises in question and recovered, and this appears to be true.
No, it appears to be true, Milords, based only on my confession. They have no idea how I've got this. Now, please read that part of the FIR where they say that this is all from the person, what he has indicated. This is the seizure part which your lordships were pleased to read, Milords. Please see the FIR.
No, since the rule, as I follow, having seen the relevant judgments, that if I find that there is a prima facie ingredients are found for investigation, it's not a routine procedure, Mr. Dev.
No.
It's not a routine order which is required to be passed on an application under Article 226 seeking interdiction of High Court in a criminal proceeding.
Lordship,
So
please.
therefore, if these ingredients are there, I'm not at all satisfied with regard to the case.
Because please allow me to persuade, my lords. I am on the malefides as far as the beginning of the starting of the investigation is concerned. That at 3:15 a.m., who gave them the information that this is there? Obviously, it is not as what is written in the FIR. Your lordships have to see the FIR. Therein
Let the investigation be proceeded with.
No, please see the sections.
I will not interfere.
My lords, kindly see the sections that is invoked. It can't be invoked. On that, your lordships will see whether that section is made out for a quashing of an FIR.
Whether the sections have been rightly invoked or not,
Yes.
that is a separate thing. But there are the ingredients which are there. So let the investigation be carried out.
Look,
And if you find that during course of investigation, these sections were not required to be fastened, in that event, you approach the jurisdictional magistrate.
my lords, in the quashing itself, your lordships have to see, my lords, with respect. Those are the judgments. Whether suppose I am today accused of cheating, and the cases of cheating are
And
there.
if you are in custody, apply for make an application, move an application under 483.
It's not me. The person who is in custody is there. That is the.
And the petitioner, he is
Yes.
out of country. Let him move an application under
Let's
483.
kindly allow me just for a moment.
Why this court will entertain this Article 226 application
Because this
seeking
section-
quashment of the proceeding?
Please, my lords, lordship may have a look at section 111 for a moment, my lords. The primary allegation against me is under 111 of the new BNS. 111 is adopted from section 15 of UAPA. Please see, now we have UAPA, which is incorporated under BNS. Those are the offenses of organized crime. Now, this organized crime, my lords, requires that certain charge sheets have to be filed for the invocation of section 111. That certain charge sheets have to be filed 6 months before in cases. Now, if that criteria is not fulfilled, my lord, there is no way that 111 can be invoked. That is one part. They have invoked cheating. Who have I cheated? There is no complaint. It is the police officer who goes, who recovers. There is extortion, not a complaint. Lords, we have to have some sort of a semblance of the rule of law as far as not a police officer who is the roaming sheriff, my lords, who goes around entering people's house in early morning 3:15. Kindly see whether those offenses.
And it was things were recovered, valuables were recovered.
Yes, my lord, but
That not from the almirah of the person.
the law, my
It
lord,
is from cupboard.
lords, I respectfully submit that law is not about proof of the pudding is not in the eating.
But at
Merely
this
because
stage-
I went into
But
it.
at this stage, court is not required to go into
But
this
100
aspect.
your
That
lords-
will be considered
Because
during
your
trial.
lordships are required to see, my lords, at the stage of quashing, whether the ingredients are made out. All judgments on quashing, my lords, from Haji Iqbal, etc., my lord Muhammad Wajid, are on whether ingredients are made out. My lord.
Haji Iqbal, paragraph 14 says attending circumstances.
Yes, my lord, that's
I am not at all satisfied with the attending
Pending
circumstances.
circumstances is because, my lords, kindly see, this is a crack of dawn operation. They could not have done it any other way. And therefore, the source information, because they don't even have one complainant before them. Not one.
With regard to incorporation of section 111, you can approach jurisdiction magistrate.
No, my lords, how can I go? My lords, that's why the cheating, that's why it is before your lordships as far as quashing is concerned. Because all quashing judgments are whether the ingredients from Bhajan Lal.
Paragraph 33.16 of Niharika infrastructure, it has
Yes.
been succinctly decided by the Supreme Court that when there are preliminary ingredients found,
Yes.
this court, while considering writ petition, is not required to find out the veracity of allegations.
Yes.
So therefore, since the investigation is at the nascent stage,
Yes.
so therefore, investigation should be permitted to continue.
Yes.
And if you find that you have a case, then move an application under section 482.
Because I'll explain this by way of analogy.
Yes.
Suppose the FIR said murder, also in it, old 302, now 103, my lords, old 302. And I came before your lordships to argue, my lords, there is no murder that has taken place, my lords. Your lordships court, my lords, under 226 or 482, my lords, would necessarily have to look and ask them that, look, how is this made out? This offense has not taken place. That is precisely what quashing is, my lords.
But that does not appeal to this court in view of the huge valuables which were recovered on 29th and 30th.
My lords, 2 points, my lords. Recovery of valuables, again, I reiterate, my lords, and resubmit before your lordships, that is not an offense under any of the provisions of BNS. Not one is an offense. Either I can have as much. They should have informed the income tax authorities. Income tax authorities would have come, and income tax authority would have seized the goods and proceeded in the manner they thought best. But till date, income tax is not there. Their allegation is that I'm indulging in illegal sand mining. Now, illegal sand mining, my lords, is covered under the MMDRA Act. It is a complete code by itself. Not one provision of MMDRA Act has been invoked by them. This is completely overreaching the jurisdiction, my lords, of the police. There is nothing more in it. Please have a look at 111, my lords, if that can be invoked at all. And the sections, no.
The petitioner has left the country.
Because they went in May, they could not have foreseen. There is no FIR, there is no proceeding against me.
And not only this, this criminal proceeding which has been initiated based on the FIR, which is at page 93, rests on 111. There are other sections, 316, 316, 5, 318.
Yes. Now,
so
please,
let it be investigated upon.
I'm obliged to your lordships that it fell from your lordships. They are relating to offences in 2021. I have a chart with me. I can show to your lordship. Those 6 FIRs that they have mentioned, that we have 6 FIRs against them, relate to an offence has taken place in 2021, according to them. 21, an FIR registered 5 years after that. Obviously, my lords, that is obviously done on the basis. If I can hand over the chart with the summary of those allegations.
This chart is there, page 167.
167, my lords.
Yes. Of your writ petition.
Same chart, my lords, but this is more elaborate.
Come to page 167.
Yes, my lords.
Of your writ petition.
Yes, my lords. I am at 167.
Yes.
No, this doesn't.
The oldest one is 7 July 2025.
No, I know, but
But all are 23rd of May 2026, 1st of June 26, 19th May 2026, 4th of July, then 6th of July.
They don't indicate the date of incident, is what I'm saying. That is why I've handed over this. The more details.
This is not a case, Mr. Dave, that that the alleged commission of offence took place 5 years back, and this writ petition is criminal prosecution has been initiated based on FIR.
No,
this seizure was there was a seizure, and this seizure was on 29th of July 2026, and FIR was registered on 30th of July 2026, if I am not wrong.
My FIR is registered on my confessional 30th July on my confessional statement of the co-accused. It can't be, my lords. That's strictly covered by Agnu Nagesya, where Supreme Court said, my lords, it is barred. You cannot.
Court is also disturbed because court has to consider the attending circumstances. Rightly, you have pointed out, as it was observed by the Supreme Court on paragraph 14 of Haji Iqbal, that the petitioner is like Indrajit in Ramayana.
Yes.
He's watching the proceedings behind the cloud.
Because the paragraph that is falling from your lordship, my lords,
Yes.
I know Haji Iqbal, allow me, my lords, I argued it, so therefore, my lords, I have some nostalgia for that particular.
That is the privilege of this court.
Yes, my lords.
To hear Mr. Dave in this
I'm
matter.
obliged, I'm grateful, my lords. But Haji Iqbal is where it is the malice on part of the investigating agency, then those attending circumstances will be looked at by your lordships. For the first time, my lords, apart from Bhajan Lal, that clause 6 of that at 6, whether there is any malice, my lords, Supreme Court had said, my lords, not to look at, only look at whether offences are made out or not. Now Haji Iqbal opened the door a little, that if it is actuated by malice, then your lordships in 482
But
to
if the
26
petitioner is out of the country, then what order you require?
No, my lords,
You are free there.
Oh, but my lords, this is my
You are
country.
free there, Mr. Dave.
Because I can understand if after the FIR I had fled, then your lordships may shut the door and say, look, Mr. Dave, your client left without on the juice. I'm already away. I'm not in India. And then the FIR is registered, my lords. And then, my lords, if I come back.
Come to page 167.
167.
Yes, again, let us come to page 167.
Yes, my lords. Uski copy do na, wo chart.
On the date petitioner fled, there is an FIR 150/2026 dated 23rd May 2026.
Please see that FIR.
Right? Then please serial number 4, 19th May 2026.
My lords, please see this chart, my lords, that I've handed over. It would shock the conscience of this court with respect, I'm saying. So if after 21, merely because there are certain changes that take place, my lords, does not entitle the state police.
This matter does not relate to the political change.
It does, my lords. It is borne out by the
because
first
the petitioner
FIR.
is not a political person.
My lords, 167, your lordships may see, the first FIR, which is registered on 19/5/26, is relating to an allegation of 4/5/2021. 2021. How does a person know, my lords, that in something that happened in 21, FIR is going to be registered in 2026?
No, but I am not on this 19th May 2026 FIR.
Yes, even the other.
I am on with regard to Mohammad Bazar police station case number
316.
20 that is dated
23/5. That is also relating to an allegation a year earlier, 1 year earlier, my lords, that the complainant had hired a vehicle for 25,000 per trip. And therefore, the cheating case is now levied against him.
FIR number 267.
267.
Page 93.
267 is the present one.
Yes.
267 is the present one, but all the other, which is
There in the present one, there is no issue that the incident relates back to to a date of which is that the alleged incident took place 5 years back.
Because there is no incident, there is no date of incident in the present FIR. There is no incident.
Very basis of this initiation of proceeding is the seizure.
My lords, yes, I'm again laboring, my lords, for your lordship's consideration. For criminal law to kick in, there has to be an offense, is what my submission is, my lords. Here, there is no offense. There is a recovery, which is not an offense under BNS. Under BNS, it cannot be prosecuted by the police, is my respectful submission. If there is an offense pursuant to which recovery, investigation, etc. takes place, then one can understand, my lords. But here, it is the other way around. There is a seizure investigation trying to find an offense. Now, please ask them, holding currency notes.
But if we come to section 106, there is no bar.
So
let us come to section 106.
But 106 assumes that there is an offense, my lords.
Let us see.
The entire code of criminal procedure. I'm sorry, my lords, I keep referring back because I'm still not as well conversant with BNSS, my lords.
Yes, 106.
And powers to search. Any police officer.
Who says so? You are not conversant.
No, I mean with the sections, my lords.
Come to section 106.
Yes, my lords. I'm obliged. Any police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offense. Again, my lords, offense. There is no offense. With respect, my lords, what is the offense? Please see. If there is an offense, that's why I'm saying, my lords, how does criminal law kick in? Your lordships are, I don't have to labor on that part before your lordships, my lords. Their jurisdiction comes when there is an offense. They find something, please inform the income tax. Please ask them to go there. Please ask them to see.
What they will do, this court will not direct at this stage.
But
let the investigation and be carried on, and let it be continued.
But my lord, there is no. But please, now where your lordships has the book, my lords, please have 111 of this BNS. Please have 111.
BNSS.
BNS, my lords. BNS. That's the IPC.
BNS.
Yes.
Oh, organized crime.
Organized crime. Please see.
Just. Yes. 111.
Yes, my lords. Any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber of crimes, trafficking of person, drugs, weapons, illicit good or services, human trafficking for prostitution or ransom by any person or a group of persons acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute and organize. And please pause here, Milot, for a moment. It talks of and continuing. This is continuing because it's borrowed verbatim from section 15. Now, organized crime means the group of two or more persons who, acting either singly or jointly as a syndicate or gang, indulge in any continuing unlawful activity. Continuing unlawful activity means an activity prohibited by law, which is a cognizable offense, punishable with imprisonment for 3 years or more, undertaken by any person, either singly or jointly, as a member of organized crime syndicate or attempt to commit culpable homicide, organized crime on behalf of such syndicate in respect of which more than one charge sheet has been filed before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offense and includes economic offense. Now, please mark this.
This is the definition of continuing unlawful activity.
Yes, my lords. In that, the criteria for invocation is that I should have one charge sheet filed in the previous 10 years on which a court has taken cognizance.
Now, if we go back to section 111, subsection 1,
Yes, my lords.
for my understanding,
Any continuing law,
any continuing unlawful activity, including kidnapping,
robbery,
vehicle theft,
yes,
extortion,
yes,
land grabbing,
yes,
contracting, then economic offense.
yes, no doubt.
Yes, then economic offense is also defined separately.
Yes. But
Criminal
continuing,
breach of trust, forgery, counterfeiting of currency.
yes, that
Now,
comes,
the criminal breach of trust is one of the sections fastened,
no doubt, my lords.
section 716.
But
So why this court is required to confine to the definition as attributed under section 111,
because the
subsection 1II.
because the offense is of continuing unlawful activity,
Really continuing.
which is organized crime. Organized crime is a continuing unlawful activity. That unlawful activity sub-ingredients are robbery, extortion, etc. But continuing unlawful activity, because it is continuing, is separately defined in Roman 2, by meaning that for it to kick in, necessarily it has to have a charge sheet which is filed in the preceding 10 years on which cognizance is taken. That is a given, my lord. There can't be a quarrel by anyone on this particular proposition.
Including economic offense. Yes.
My lord, so please see this.
So your submission is this continuing unlawful activity includes economic offense.
It
So
does.
therefore, continuing in order to constitute the offense,
Of-
which is to be termed as continuing unlawful activity,
Yes.
then there is a requirement to satisfy the conditions as stipulated under 111(1) II.
Lordship, please. Because this is an offense which is separate from those sub-ingredients that are mentioned. I can be prosecuted for robbery separately. I can be prosecuted, my lords, for theft, extortion. That as an individual. But if it has...
If in a criminal prosecution, there are several sections fastened
Yes, my lord.
or incorporated.
Yes.
Now, out of which, if it is found that one section may not apply in a
Yes.
particular, in a given situation,
Yes.
in that event, that liberty is always there to approach the appropriate forum.
Because
For that, you need not approach the.
I will-
In Article 226, I will grant you leave.
My lords, I will address, my lords, and best to my endeavor show none of the sections apply.
No, that I will not.
None.
I will not treat at this time.
My lords, your lordship,
At the nascent stage.
at this stage itself, my lords, they have to be. Because if there is no other stage available to me. Tomorrow, if they file the charge sheet, my lords, the objection will come. Now,
Because
charge
I am
sheet.
not hearing. It is not a trial going on.
No, not a trial.
Let the investigation be carried out.
I am asking your lordship to see it on the face of it. From the FIR, your lordships have seen, which talks about seizure of two kinds of commodities. One is cash and one is gold. On that particular seizure, my lords, your lordships may see as far as whether any of these offences are made out, my lords. That is all that I'm asking your lordships.
Mr. Dave, in that event, I will not. I am not satisfied with regard to passing an interim order. If you pray for, I can direct the parties to exchange pleadings. Otherwise, I have to pass a final order.
No, my lord, then-
Choice is yours.
No, my lord, I bow down, my lords. Of course, I see what is falling from your lordships, my lords. But as far as then, my lords, on a prima facie basis, if I establish this, that I have an arguable case before your lordships, my lords, that I am arguing it, subject to whatever the other side may argue before your lordships today. My revision, which is there also with this, that they are taking steps. I can address that part also before your lordships then. This is an arguable case, though it comes across.
But I don't want to mix up your revisional application with this 226 because the parameters are different and the different scrutiny is required to be considered. Should be resorted to.
My lords,
So therefore, I want to decide this 226 application first.
even assuming your lordships decide this against me, my lords, for a moment I take it that your lordships are not inclined in this. Even then, my lords, my revisional petition, I can show to your lordship the manner in which non-bailable warrants are issued and the proclamation is done by placing reliance on two judgments of one of the Honorable Supreme Court and one of your lordship's court, is completely, it doesn't apply itself. On the first date itself, my lords, on the date there is a non-bailable warrant issued. How is a non-bailable warrant issued, my lords, on the first day itself, where the police has made no effort to locate me or find me or done anything apart from that first day? And the magistrate says that in Dawood Ibrahim's case, my lord, Supreme Court has said that I can issue at the stage of investigation, so therefore I'm issuing. That is the only criteria which is the issuance. And in the second time, when it comes from proclamation, he says, I have issued it based on Dawood Ibrahim, and therefore I'm issuing the proclamation. My lord, surely these, and the Supreme Court and your lordship's court has said, these are matters of serious nature because they attach a criminality to a person, my lords, issuance of a non-bailable warrant. And Dawood Ibrahim was a case where after filing of charge sheet, 167 remand came into play, and on that remand, my lords, it was a question of persons against whom charge sheets had not been filed, whether they could be arrested or they could not be arrested. Now, if your lordship think, I am only praying that as far as the investigation is concerned on the first, if your lordships are not inclined at this stage to interfere with and hear the matter finally on a particular date, but as far as revision is concerned for a person who was not in the house, whose house it is not, and based solely on the confessional statement of the brother-in-law, he has been implicated, and that confessional statement has been set out in extenso in the FIR itself, my lords. It is astounding how a confessional statement can be there in a FIR. Please see the FIR if your lordships have seen it, but please read with me, my lords, that part where he says.
So in that event, let me pass an order in 226 application.
In the writ petition, let the affidavit come, but there is another prayer. All my properties are
Of course,
seized.
after hearing the
Navina-
learned advocate
Navina-
response.
Even Navina-
My lords, there is one as far as seizure of
Because
all,
I will not mix up those two matters.
no, I'm not. In the writ, my lords, there is one subsidiary prayer which is there before your lordships, which is there that they are going on attaching all other properties of mine. They have enough material of mine with them, my lords, as is evident from the FIR itself, my lords. It's not some small amount which is there. Are going around attaching for the time being those coercive steps your lordships may consider. If they don't apply, my lords, these sections. Suppose your lordships come to a conclusion on the next date, and I'm able to persuade your lordships, my lords, that none of these sections are made out, and your lordships agrees with me and asks the state, my lords, this is not an offense under BNS. Seizure of money and gold is not an offense under BNS. Please report to the income tax authority. Then, my lords, all these attachments, my lords.
Yes.
That is the judgment of Supreme Court in Nevada, my lords, that I may place before your lordships. This.
And my sealing of my house cannot happen on the first day. My house, my para 9 of the para 9 of the writ
धीरे
petition.
बोलना वो ना।
Para 9 of the writ petition had
Now, please see, my lords, this.
Just a minute.
Sorry.
just see this para and then show the writ.
This is your prayer.
No, this is what they have done on 30th, you know. 6. You cannot.
Para 9 क्या है उसमें?
Yes.
My lords, paragraph 31 and 32 of the second judgment, Nevada, my lords, which starts, my lords, at page 4.
Page.
Page, my lords, I'll read from the scope of 102, which actually starts, my lords, from page 22.
Can I have the reference, please? Can I have the reference?
Oh, sorry. It's 2019-20 SEC 1.
Sorry. Yes, sir.
এই এসিটাকে একটু বাড়াতে বলুন, শুনতে হচ্ছে এসিটাকে বড় ইস ইজ নট ফিলিং কমফোর্টেবল ইটস Yes, it starts from page 4.
Page 4.
Nevada judgment.
Yes, my lords. Para page 22, my lords.
Yes, page 22, paragraph
28, my lords. Para 27 is the conclusion. Lords may have a glance, my lords. I apologize. Having held and elucidated on the power of the criminal court, we find good ground and reason to hold that the expression any property appearing in section 102 of the code would not include immovable property. We would elucidate and explain. The first part of subsection 1 of section 102 of the code relates to the property which may be alleged or suspected to have been stolen. Immovable property certainly cannot be stolen and cannot fall in this part. The second part relates to the property which may be found by a police officer under circumstances which create suspicion of the commission of the offense. We have already referred to the judgments of the Delhi High Court in P.K. Parmar, Swan Sabarwal and Jagdish Chandar, which have elucidated in a restricted and narrow manner defined the requirement for invoking the second part. However, we have come across a decision of this court in Tista Setalwad on an appeal from the judgment of the Gujarat High Court and had dealt with the situation when an act of freezing the accounts was a sequel to the crime as the crime was detected earlier. The Gujarat High Court took a somewhat contrary view by not interfering and directing defreezing, observing that even if the action of the investigating agency at inception to seize may not be regular, the court cannot be oblivious to the collection of substantial material by the investigating agency which justifies its action under 102 of the code. Further, when the investigation had progressed to a material point, defreezing the bank accounts on the basis of such argument would paralyze the investigation, which would not be in interest of justice. After referring to the factual matrix in Testa Setalwad, this court observed that the investigating officer was in possession of material pointing out the circumstances that had created suspicion of the commission of an offense, in particular that investigation and therefore exercise of power under 102 would be illegitimate as it was exercised after following the procedure prescribed in 2 and 3 of the same provision. 102 postulates seizure of property. Immovable property cannot in its strict sense be seized through documents of title, etc. relating to immovable property can be seized, taken into custody.
This is a case of defreezing of account.
Sorry.
This is a case of freezing of account.
In our case, my lords.
No, it's a case which you are
of my lords, freezing of attachment of properties, my lords.
Freezing of account.
And immovable
account was debit frozen, probably.
Sorry, my lords, it was.
So how does it relate to the present case when on seizure it is found that a huge amount of gold bars, silver and cash were recovered from cupboard?
This para 9, my lords, in my writ petition, para 9 in my writ petition deals with the immovable properties being seized.
No, but it has to be considered based on the facts of the present case.
It can't be.
Immovable property may have a wider connotation, but that does not mean that the freezing of bank account would be related to
Not
the present facts of the case, where huge amount was gold bars, silvers, and cash were recovered from cupboard.
In that house, my lords, which is falling from your lordships, as a crime scene that can be sealed, my lords. My properties, which I have addressed in paragraph 9 of the writ petition, your lordship.
This matter, the facts of the case, so far this Nevada is concerned, is relating to freezing of account.
And that says you can't attach immovable, you can't seize immovable properties because immovable properties cannot be stolen, immovable properties can't be there. Kindly see para 29 and 33 and 34 specifically. Please see that, my lords. Para 32 specifically, I will not read the others. In case, at page 24, in case and if we allow the police officer to seize immovable property, please see this, on mere suspicion of the commission of any offense. Sorry.
What of him? Who to that? Your house.
Maybe I'll be.
But it talks about seizure of immovable property, attachment of immovable
Cannot
property.
be done.
But how? But in this case, the movable properties and the valuables were recovered.
No, but now they are. That's my prayer in the writ also, my lord. That's why I was pressing for the interim stay, since it fell your lordships would hear it. A para 9 in my writ, they are attaching my residential house. They have attached my office buildings. All that can't be done in view of the Supreme Court judgment. You can seize whatever you want as far as immovables, because otherwise you will become the police officer, not you, my lord. Sorry, the police officer will become an adjudicator, is what the Supreme Court says. So those properties have to be ousted. A residential
No,
building.
but the court is focused so far. The present case is concerned with regard to the seizure made on 29/30th.
But that is there. That is
But
against.
during course of investigation, if such attachments are made, then you have to approach the appropriate forum.
Your lordships is the forum. There is no other forum I can go to.
You
There
can approach the jurisdiction magistrate.
Jurisdiction magistrate has no power. There is nothing before him. This is an administrative. This is an action by the police. Only your lordship's wide powers under Constitution, my lords, under 226 can protect a citizen, my lords, between the guardian between the state action and excesses, my lords, and the citizen. However bad the citizen may be, my lords, but your lordship's powers are operate, my lords, without any looking at what search, seizure, that particular property, assuming, my lords, that's a scene of crime, are seized by them. But can't go on sealing all my immovable property, including my residential premises. Please see my prayer, my lords, in my writ, page 11.
Page 11, para 9.
My lords, I'll just read. Sorry.
Yes.
My lords, therefore, my lords, with relation to immovable, though aside, that's why the Honorable Supreme Court.
There is a case made out in the writ petition regarding
lords,
attachment.
paragraph 9 I have mentioned, my lords, page
11.
page 11, para 9, my lords.
And prayer.
Slowly.
Page 9, paragraph 4.
No, page 11, paragraph 9, my lords. Sorry.
Right.
Very confident. Trying to
Yes.
My lords, specific prayer is prayer
70, page 71.
page 71, prayer E, my lords, if your lordships are pleased to turn to that. I have it.
71B.
Lordship, please.
B.
B and E. and E, my lords, specifically.
What is the fact of the case so far Nevada is concerned?
Nevada also, my lords, was a case where, pursuant to some disputes between the parties, the immovable property was being sealed. Pursuant to the disputes between parties, my lords. Page 4, if your lordships are pleased to see. I'll just show your lordships the. But Nevada is emphatic, my lords, on the power. It's a declaration of law by the Honorable Supreme Court, my lords. Once again, he wants the facts. No, my lords, I'm sorry. It was on a reference. It was a reference to a larger bench in view of the conflicting judgments, my lords, that your lordships will find at page 11 itself. Honorable three-judge bench, my lords. A division bench of this court, video order 1811, noticing that the issues are
reading paragraph.
page 11, my lords, page 11.
Yes, page 11.
The first paragraph, my lords. Noticing that the issues that arise have far-reaching and serious consequences, had referred the aforesaid appeals to be heard by a bench of at least 3 judges after obtaining appropriate direction from the Honorable Chief Justice.
What was the reference?
My lords, the reference order is referred to, my lords, in just take out 2014 SCC online. And the specifically Nevada's case, my lords, is paragraph 2. For the sake of convenience, we have, while I take out the reference order, my lords, we have treated the criminal appeal arising out of specially filed by Nevada as the lead case. The appeal arises from judgment of High Court of Judicature of Bombay, wherein the majority judgment has held that the expression any property used in subsection 1 of section 102 of the Code of Criminal Procedure does not include immovable property, and consequently a police officer investigating a criminal case cannot take custody of and seize any immovable property which may be found under the circumstances which create suspicion of the commission of any offense. According to the majority judgment, earlier decision of division bench of the same High Court lays down the correct ratio, and the contrary view expressed in Bombay Science does not lay down the correct view. The minority view holds that the police officer has power to seize the property, whether movable or immovable, under 102 of the code, and the decision of the High Court in Bombay Science and Research does lay down the correct law, and Singapore is not good law. And the reference,
this was the issue.
Yes, specifically. Bombay High Court had a larger bench also, and there was a majority and a minority. And then it came up, my lords, then there was a batch because these issues must have arisen across high courts, my lords, and therefore the matter was placed. वो judgment निकालो ना, reference वाला.
Reference निकालो.
Yeah. They use it. Yeah. That's a declaration. Correct.
Yes, so precisely.
My good friend from Delhi, Malad,
My dear friend, Mr. Bhattacharya.
he has made his overwhelming presence felt. Just that, Malad, we cannot have lunch or dinner together today since we are opposing each other, not appearing together. But the purpose is, my lord, of the petitioner to call out information regarding the development of the investigation. There are attempts, my lord, is operating from overseas. It's a very, very confidential report. My lord, may kindly, my lord, reseal it and hand it back, or my lord, keep it, my lord, in my lord's custody, my lord.
I don't know what the document is, my lords. I am on my writ petition and for quashing and these ancillary prayers for the time being. Let's see what that is. Stage of investigation. What you were doing? Yes. It is
4 July.
they had a
No, 4th August.
full status report.
Nothing.
This is the status report that we do.
4th August. It's a
If you want to keep something which is across the bar, if we are disclosing everything, disclose something and this the clear secrecy in terms of official secrecy.
नहीं हो सकता can't ask.
You guys to ensure that you don't get your life where small issue of affecting but it's making a dent. Yeah, making a dent. I understand strategy.
ये तो दूसरा चिदम्बरम सील्ड कवर का ट्रिपल टेस्ट है
29. अच्छा my house. Can you this is as of today. Can this be done? Is it a sleeping station for police? Obviously. They don't have house. I don't know. Sure.
I agree.
There are reasons for incorporating section 111. It's an organized crime which is going on, as a result of which government is losing revenue. Stone mining is going on, and that this duplicate carbon receipts are being issued in order to obviate payment of.
Kindly, my lord, kindly not
Yes.
divulge, my lord. I would pray.
Because the envelope that has been handed over, my lords, is a practice that has been deprecated by the Supreme Court in the Chidambaram judgment. It is I am entitled to a status report by them in
So
the
your points, Mr. Dave, is this that
lodged by
first of all, based on seizure, this proceeding should not have been initiated,
yes,
as you have stated.
lordship.
As this point you have taken, and you are also you have complained of incorporation of section 111 of BNS.
Yes, and all
Because the
others.
requirement under as stipulated under section 111 1 II is not fulfilled.
Lordship.
This is the third point, and you have relied upon paragraph 32 of Nevada judgment.
Yes.
Yes.
And my lord,
No further, please. Yes. Yes. I have heard. Yes. Mr. Mitro, anything you want to add?
Yes, see, the investigation is, my lord, at the beginning, my lord, that is being carried on.
Magnitude of the crime.
And my lord, your lordship has seen, my lord, the magnitude of the crime. Now, my lord, 111, my lord, it can be done, my lord. I can show your lordship, but
But only thing that
yes,
where I am asking you, as Mr. Dave has taken this point, if you come to 111 and the definition as of
BNS.
continuing unlawful activity,
yes,
because if you consider, if you go through section 111 subsection 1,
yes,
any continuing unlawful activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cybercrime, trafficking, so and so forth. Now this will constitute organized crime. Now while giving the definition which is offered under section 111 1 II, continuous unlawful activity means an activity prohibited by law which is a cognizable offense punishable with imprisonment.
yes,
Imprisonment of 3 years or more undertaken by any person, either singly or jointly, as a member of an organized crime syndicate, or on behalf of such syndicate in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years. So where is the fulfillment of these conditions? Uh, uh, Taking note of the definition of continuing unlawful activity.
Yes. Now, my lord, two charge sheets have been filed, my lord, and court has taken cognizance of it. The report bola bodhay ami jai na.
Charge sheet has to be filed before invocation of 111, not after invocation of 111. That charge sheet is, I don't know what is being handed over, but if that is after 30th of July, then it doesn't fall within the ambit of 111, my lords.
167 charge is there referred in the FIR. Tell me about
But these are the charge sheets after the initiation of, after registration of FIR.
এগুলো কি?
filing
I know it.
after filing of the writ.
I know it. I know it.
After filing of the writ.
After filing of the
Line. Ground, defeat the ground. Line is a
गुस्सा हो रहा है वो देख दोनों में ये खराब है the same problem.
They quoted in the writ.
There is one charge sheet you have filed, that is 4th August 2026 in connection with this is final report charge sheet number 1979. In FIR number 220/2026, Police Station Mohammad Bazar 2026. This is one charge sheet. And where is another? Also 4th August 2026. In FIR number 2116/26 dated 4th July 2026. These are the two charge sheets.
Lord, may I pray that your lordship's district
But as it is being argued that before initiation of the proceedings, if there are preceding other charge sheets, more than one charge sheets as contemplated in the definition, anything is there?
Well, I have to take instruction, my lord. That's all.
Thursday. Give us a copy of the charge sheet.
What is your response to that?
To?
With regard to this fulfilling the conditions
Kindly come.
arm the alleged offence
Yes.
as an offence under section 111.
Kindly come to my lord 111 once.
Yes, yes.
Any continuing unlawful activity, including including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offence, cybercrime, trafficking of person, drugs, weapon or illicit goods or services, human trafficking for such and such, for by any person or a group of persons, acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence, threat or violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. Then, my lord, kindly explanation. Kindly come to, my lord, the 2. Continuing unlawful activity means an activity prohibited by law which is cognizable offence punishable with imprisonment of 3 years or more, undertaken by any person, either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years. And that court has taken cognizance of such offence and includes economic offence. Now, my lord, with respect, my lord, it does not say, my lord, when, my lord, this cognizance has to be taken. The offences are, my lord,
I know.
now, my lord, in any event, as on date, assuming, my lord, it was not there, my lord, this section could have been added subsequently also. This 111 could have been added subsequently also. Now,
After filing of this charge sheet.
yes, additional charge sheet could have been filed. So there is no difficulty.
But as on date, there are 2 charge sheets.
Yes. And, my lord, the investigation is going on, my lord. Several persons, my lord, have been apprehended, my lord. Possibly that would. Including, my lord, officials.
Because may I only pray that your lordships may
Yes,
consider
and
this.
study. And the gold bars.
They're all Swiss gold bars. This is the Hawala Nexus also.
Mr. Bhattacharya may know that you can buy Swiss gold bars in India in a shop also. It is not so that you have to go to Switzerland to buy Swiss gold bars, my lords. That's not the criteria. Now, this, my lords, on 111, I'm laying emphasis on 111, my lords. And
But Mr. Dave, only,
I would
on
like to
this,
assist.
only on this point
my lords, I would like
of
to assist.
incorporation of section 111, whether it is rightly incorporated or not, I am not inclined to
Then may I-
frustrate the prosecution which has been initiated.
Because
against the
I want to assist your lordships on this on 111. And on 111,
considering the magnanimity of alleged offence.
because if it was so of such
Considering the magnitude of
if it
alleged
was of
offence.
such magnitude, my lords, as is sought to be made out, as if it threatens the sovereignty, integrity of India, as if it is of an offense of such a nature, my lords, that NIA is investigating, some terrorists are involved, it is not. I am not far removed from mining. I have been mining and I have licenses for mining. It is not that I am a person who does not hold licenses and I've been mining. I've placed those licenses on record before your lordship. I am involved in the profession of licensing, of mining. and I have licenses for that. Now, if I breach those licenses, I have mined more than what is I'm authorized to. I have mined less. They are all under MMDRA Act, my lords. This can't be. But I would like to assist your lordships on 111 specifically, my lords. Today, my lords, I'm only praying because this is borrowed from Maharashtra Control of Organized Crimes Act, my lords. West Bengal does not have such an act, my lords. As yet, it does not have it. That act has been extended to Delhi by the same title, Maharashtra Control of Organized Makoka, what is known as otherwise Makoka. And the language that is borrowed in 111, my lords, is almost identical from this. Today, I don't have the judgments for it, my lords. I would like sometimes next week, my lords, to come back and assist your lordships on 111 and this exact interpretation that I am submitting before your lordship. If your lordships give me the chance, the judgments of MCOCA, my lords, apply identical to the provision as far as this 111 is concerned. And the criteria as to not only filing of charge sheet, it's not enough. A magistrate or court should have taken cognizance, my lords. That is the second. After having wrongfully invoked it, can't say I can add it any point in time. Because after all, they are police. They are subject to some rules and regulations. My lords. It can't be that I'm running riot and doing whatever they feel like. That is why, your lordship, I would like to assist your lordships, my lords, if your lordships permit, on 111 and come back and show the judgment which is identical on that. And as of today, I have police officers.
Today I will close the matter so far 2022.
I have police officers sitting in my house. They made it into a police station as far as this is concerned. I have photographs.
There are confessions before the police officials that these are the wealth and these materials are materials belong to whom?
My lords, your lordships.
There are confessions. So at this stage, at this initial stage, whether it would be
attempts, my lord, to
my lords, if you're
with the witnesses and the evidence, my lord.
my lords, if the best evidence that they have is of confessions, my lords, that means the police is the weakest investigation. Confession of a co-accused which won't even stand to trial. Confession of an accused which does not inadmissible in evidence is the best evidence that the police has of today, my lords. Your lordship's court will not countenance for the police. If it is admissible under a particular act, I can understand a statement, especially under ED, PMLA, some statement is admissible because of Vijay Madanla. But today, my lords, is what has been handed over to your lordships in a sealed cover, which I am not privy to, they don't want to disclose. But to say that this is of wide magnitude, my lords, and there are confessions that are there of co-accused persons, their confession, their FIR starts with confession. Please see the confession in itself. And what is a confession?
no at this stage whether court is not required to enter.
But court will require, my lord, to see the material objectively. They are only placing, my lords, in a sealed cover before your lordships the material that is there, which I don't know. If I had been shown, any criminal lawyer, my lords, worth his salt would have said this confession is not worth the paper it is written on. It is not the accused who writes it, unless it's a magistrate confession under 164.
At this stage,
At this stage or any stage, unless it's a confession made under 164, my lords, it is not worth the paper it is written on. And therefore, my lords, your lordships may not countenance that as far as giving this picture that is of wide magnitude. My lords, if today the police changes or something changes, these very persons who implicate this will implicate someone else. That's why even the British people didn't realize that 25 and 25 is retained in BNSS. For some reason, my lords, there is a reason why it is there. And that is the best evidence. Please allow me on 111, my lords, and to place some judgment before your lordships, my lords, that even certain provisions at the time of challenge can be quashed by your lordships at the 226 stage. It is not, if it is not made out, it will be quashed. It can be quashed qua a particular person also. Partial quashing is now permitted, my lords, as far as FIRs are concerned. So I'm only praying, my lords, your lordships may hold it over if your lordship is not inconvenient. I will address on 111 because 111 is the most drastic of the provisions that has been invoked by them.
By presenting this writ petition, comma, inter alia, comma, petitioner has questioned petitioner has questioned propriety of FIR being FIR number 267 of 2026 dated 30th July 2026. Being Mohammed Bazar Police Station, being Mohammed Bazar Police Station case number 267 of 2026 dated 30th July 2026. Stop. Mr. Dave, learned senior advocate representing petition. Submits that based on seizure conducted by based on seizure. Yes, based on seizure, based on seizure of based on seizure, which was conducted on 28 July 2026. Aforesaid FIR was drawn up and criminal prosecution was initiated. Which is impermissible, and there is no complaint lodged against the petitioner. So, it is also contended. It is also contended on behalf of petitioner that FIR's impugned FIR reveals incorporation of section 111 of Bharatiya Nyaya Sanhita 2023. Though conditions contemplated under section 111 of BNS 2023 are not fulfilled, which would enable concerned police authority to fasten section 111. Stop. Notice of this court has been drawn to section 111 and definition of continuing unlawful activity, quote unquote, attributed under section 111 within bracket 1 within bracket II. Stop. According to petitioner, in order to attract section 111 in connection with the criminal prosecution, there has to be more than one charge sheets. There has to be more filing of more than one charge sheets before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offence. Mr. Dave, only one thing.
Yes, Malad.
While dictating the order, please come to section 111 1II.
1II, Malad. Economic offense.
You need not read in its entirety. Under II, it says either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate in respect of which more than one charges have been filed before a competent court within the preceding period of 10 years.
Yes, Malad.
Within the preceding period of 10 years.
Yes.
And that court has taken cognizance of such offense, comma,
Yes, Malad.
and includes economic offense.
Yes. Yes.
So whether this economic offense
Yes.
is kept
Separate.
outside the purview of continuity of unlawful act,
Yes. So in
because there are several
Yes.
heads or several um, terms
Yes, ma'am.
which are indicated in section 111.
Yes, my lords.
Any continuing unlawful activity including kidnapping,
Yes.
robbery,
So those are separate.
vehicle theft, extortion, land grabbing, contract killing, economic offense.
Yes, my
Then
lords.
cyber crimes, trafficking of persons, drugs, so and so forth. But while defining continuous unlawful activity,
Yes, my
this
lords.
economic offense
Yes, my lords.
uh, uh, was kept outside, as it appears that it is kept outside
Yes.
the definition which is attributed to continuing unlawful activity
My lords.
and economic offense,
So economic offences are defined, my lords, in three.
comma, and includes economic offense.
And which are defined, my lords? Which are defined. Economic offences are also defined.
Which of trust, forgery, counterfeiting of currency, in any form. So therefore, economic offense is not coming within this definition of continuing unlawful activity.
So that
And there is an economic offense. If you come to economic offense as defined under section 111,
Yes.
1 III, economic offense includes criminal breach of trust, forgery.
yes.
But there, the requirement of filing 2 charge sheets within a preceding period of 10 years, that is absent.
No, my lords. With respect.
That is absent, Mr. Dave.
With respect, my lords. The requirement is of an offence.
Because a separate meaning or separate connotation is attributed so far economic offense is concerned.
Just for a moment, if your lordship sees I. The requirement is of an offence which is punishable by more than 3 years. That's the opening line. That's the first part of I. Means an activity prohibited by law which is cognizable, punishable with imprisonment of 3 years or more. First requirement. Then it comes undertaken by any.
But that does not include economic offense.
No,
As it appears, because that's why and includes economic
my lords,
offense.
preceding 10 years, and that court has taken cognizance of such offence and includes economic
Comma,
offence.
first comma, they and includes economic offense.
For what, my lords? For the offence.
Then economic offense is defined
So
separately.
for the
So
offence.
therefore, the conditions which you are which you are arguing, that there has to be 2 charge sheets and filing of those charges before the competent court within the preceding period of 10 years, whether that will apply in
It
case of
does.
economic offense.
And that has been held, my lords, by the Supreme Court in MCOCA cases, which are identical. I have taken out the bare act, my lords. I'll just show to your lordships in this. MCOCA also has the same provision, which is there about this, which has been interpreted by the Supreme Court, because this is an older act. It's from 1992 in Maharashtra. Now, there also, my lords, if continuing unlawful activity and organized crimes, etc., are all defined. No, they won't have it here. It's not used here. They are all there. But on the interpretation of that, when your lordships reads that offence organized on behalf of such syndicate in respect of which 1 or more charge sheets have been filed before a competent court within the preceding period, and that court has taken cognizance of such offence and includes economic offence. The word economic offence relates to this offence. In the last line, my lords, in my respectful submission, the cognizance of such offence is and includes.
But if you compare it, II and organized crime under subsection 1,
yes,
there are different terms or different
yes, no doubt,
various offenses have been described.
no doubt.
Activity including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber
Economic
crime,
offence.
out of which this economic offense has been
Yes.
stipulated separately under II.
True, my lords, your lordship is right. But economic offence then forms part of the main definition of unlawful continuing activity also, my lords, there.
কি বলছিলাম? Stop. সেন্টেন্সটি কিভাবে শুরু করেছিল? Stop. Stop. In the present case, such ingredients, in the present case, such conditions are absent as contemplated under section 111 within bracket 1 within bracket II. And as such, incorporation of section 111 is bad. And is bad and impermissible. Stop. Next paragraph, reliance is also placed on judgment of the Honorable Supreme Court reported in 2019-20 SCC 119 within bracket Nevada Properties Private Limited to its directors versus State of Maharashtra and another. In order to contend that on the strength of section 106 BNSS 2023, immovable properties, lands, plots, residential houses cannot be seized in connection with a criminal prosecution. However, stop. It is also submitted that in the present criminal prosecution, immovable properties as described in paragraph 9 of the writ petition are being seized. Which supports the case made out in the writ petition that the criminal prosecution is not directed towards, criminal prosecution is not taken towards right direction, requiring interdiction by this court in entertaining the writ, in entertaining the present writ petition under Article 226 of the Constitution of India. Next paragraph, during course of argument, Mr. Mitro Learned, Advocate General representing state respondents, in a sealed cover, has filed a report of Inspector in Charge, Muhammad Bazar Police Station, dated 20 August 2026, which wherefrom it transpires that due to alleged acts and actions of the petitioner, state government is losing. State government is incurring huge revenue loss, which are connected to stone mining. Stop. It is also disclosed in this report dated 20 August 2026 that from these documents in connection with impugned criminal prosecution, it has been found that there are malpractices regarding preparation and issuance of duplicate carbon receipts within bracket DCR. Stop. However, at this stage, court is not inclined to narrate alleged acts and actions of the petition, which is subject matter of investigation in connection with Mohammed Bazar Police Station, case number 267 of 2026, dated 30 July 2026. The report dated 20 August 2026 shall be kept in sealed cover with the present record. Next paragraph. While opposing the case made out by the petitioner, it is contended on behalf of state respondents that there are two charge sheets filed one being charge sheet number 196/26 dated 4th August 2026, in connection with Mohammed Bazar Police Station FIR number 216 of 2026, dated 4th July 2026, and another is charge sheet number 197/26 dated 4th August 2026 in connection with Mohammad Bazar Police Station, FIR number 220 of 2026 dated 6 July 2026. Stop. According to the state respondents, while determining the issue whether in the present in the impugned criminal prosecution section 111 of BNS 2023 needs to be incorporated or not, these two charge sheets ought to be taken into consideration. Next paragraph. Having considered the respective submissions made on behalf of the parties and the case made out in the present writ petition, this court this court finds it apt to consider the exercise made by police authority on 28 July 2026 and seized cash, gold bars and other items from cupboard of from cupboard kept at the residence of one Minar Mondal. Stop. Teaser list prepared on 28 July 2026. Discloses a recovery of gold bars, and huge amount of cash. Stop. Properties, movable and immovable, suspected to be proceeds of crime are have been found. And based on recoveries, investigation is going on. Stop. Investigation is at the nascent stage Therefore, at this stage of criminal proceeding, court finds it improper to make an endeavor to find out the veracity of allegations. Veracity of allegations. Stop. Next paragraph. The issue which requires consideration is incorporation of section 111 in the impugned criminal prosecution. Stop. For better understanding of section 111, or for better understanding of the term organized crime, enshrined under section 111 of BNS 2023. Section said provision is quoted. Section 111 take a sit out. Stop. It was contended, it was argued on behalf of petitioner that in order to attract 111 section provisions under section 111, conditions defined under the definition of continuing unlawful activity, quote unquote, are required to be fulfilled, comma. Those conditions are against a member of organized crime syndicate or on behalf of such syndicate, more than one charge sheets whether filed or not before the competent court within a preceding period of 10 years. Stop. It appears that two charge sheets, as alluded above, both dated 4th August 2026, were filed in connection with other FIRs. Stop. Moreover, while defining continuing unlawful activity, quote unquote, economic offense was treated separately. And separate and separate definition is given under section 100 in section 111 within bracket 1 within bracket III triple I. So far economic offense is concerned, economic offense quote unquote. In the present case, apart from section 111, other sections are sections 308/316 within bracket 2, 316 within bracket 5, 317 within bracket 4, 317 within bracket 5, and 318 within bracket 3. Stop. Taking nature, considering nature of allegations made against the petitioner in connection with the impugned FIR, and there are 2 charge sheets filed, both dated 4th August 20, and there are 2 aforesaid charge sheets filed in 2 other separate criminal prosecutions. Court is not inclined to interfere with the decision of respondent authorities to incorporate section 111. PNS 2023. Stop. Concerned police authorities are directed to investigate the case in accordance with law. The petitioner has an alternative remedy under section 482 BNSS 2023 by moving pre-arrest bail application before appropriate forum. Stop. Reliance is placed on the judgment of the Honorable Supreme Court reported in 2021-19 SSC 401, Niharika Infrastructure Private Limited versus State of Maharashtra and others. Stop. Paragraph 33.16 runs infra. 33.16 টা set out করো। Next paragraph. Before parting with, it needs to be recorded here that it is admitted in the writ petition that petitioner has left this country on 23rd May 2026. Which does not instill confidence in the mind of this court. Stop. কোথায় গেল গো দিলাম numeric infrastructure. Next paragraph. এই সেন্টেন্স এই প্যারাগ্রাফটা দেবার আগে ওই নিয়ারিকা ইনফ্রাস্ট্রাকচারের শেষে একটা বলতে নিয়ারিকাটাকে কোট করার পরে বলবে রিট কোর্ট while exercising jurisdiction under Article 226 of the Constitution of India, considering a petition seeking quashment of criminal prosecution needs to exercise such power with circumspection and sparing, comma, it is not a routine procedure that on an application seeking quashment of criminal prosecution, same shall be dealt with mechanically, thereby directing the concerned police authority not to take coercive steps, especially when allegations are grave in nature and a report is filed before this court dated 20 August 2026 by Inspector in Charge, Mohammad Bazar Police Station, Birbhum, disclosing alleged actions of the petitioner. Hence, present writ petition is dismissed. However, this order shall not preclude the petitioner to take steps in accordance with law, if so advised.
By revision, revision will have to be heard now since your lordships have dismissed.
Revisional application appear on a subsequent date. You can appear online. No issue. You can appear online, Mr. Dave.
Daveda is not a side. Just pointing out to my matter.
Yes. That will be considered separately. All matters cannot be clubbed together in this fashion, Mr. Banerjee. This was mentioned by Mr. Rohatgi. I have fixed this matter. I have decided this matter. So for revisional application, it has been assigned to me. I will hear it on a subsequent, on a particular date. And Mr. Dave, you will appear online.
I can
If
come.
it is difficult for you,
I can come Thursday, my lord. Thursday is a holiday in Supreme Court. I can come here next
Thursday,
which is 27th.
holiday.
We are. There's no holiday here, but no. Your lordships are closed on 26th. my lord.
26 probably. Till date, our calendar, there is no indication, but since there might be some confusions with regard to sighting of moons and other things. So that's why Muslim festivals holidays are declared at the 11th hour.
But this is Miladul Nabi. It has nothing to do with mood. I think it's the Prophet's birthday, my lord. It's not
So when do you want? On
27th if it's not
27th,
inconvenient.
if it is not holiday, then 27th.
27th. I can come physically because we are closed then.
একটা separate order করো বা relating to the civil issue. Yes.
Can it be on 28th?
28th is Raksha Bandhan.
Stay back on Saturday morning.
I have two sisters, my lords. I dare not step out. That's the only time I stay there.
On Rakhi,
On Rakhi,
Purnima
I'm
Day.
not allowed to move out of Delhi, my lords.
27th, please.
27th, right? The Advocate General can.
Mr.
I'll tell you, Lord,
Mr. Advocate General, adjust your other matters and appear in this matter.
before the Honorable Chief Justice's bench, my lord, regarding this Badwipur incident.
Which incident?
The
Badwipur-
Badwipur incident.
Yesterday only it was fixed.
Can have it at 2 o'clock if it's not. If it's not inconvenient, we can
So
have
you
it.
discuss accordingly and tell me.
Sir, can we have it at 2 o'clock?
In every aspect, court is not required to decide.
Right.
Yes.
Very well. Kindly keep it at 2, my lord. We shall, my lord, try to.
With revisional application, give me that revisional application.